are we in the 17th century or even the 20th century? Now everyone knows what metadata is. It's just like back in the 90s when earlier you asked for what we call bench notes or laboratory notes, because that's where your forensic evidence was that showed that things were exculpatory. It was not in the actual scientific report. Now everyone knows that. But in the metadata, what are we talking about? If you're preserving the video, the interpretation of preserving any video is to preserve the metadata. That's what the police are looking for, right? They're looking for when something was sent or when something was changed. They download the metadata. Hello?
Yep, but by drawing that distinction, I think it's going to be abused in the future. That's my guess.
Yeah. And so, so the metadata, apparently you have to specifically ask for metadata. Now, so they get around this whole idea that the video was, remember the whole idea of the defense wasn't told that there was, first they were told the video was overwritten. Then it turns out there was a copy of all these videos that weren't deleted on another drive. And then it turns out that drive was put on a jump drive by somebody else 2 days before he retired. And then it turns out that jump stick without the metadata, because it was
cut and pasted, I guess,
captured by drag and drop, which deletes the metadata, changes the metadata, was in Trooper Proctor's file. So if you're not screwed, defense, on one aspect, you're screwed on another aspect here. That's what this opinion is basically saying.
I didn't see that. I didn't see that in the decision. But
you didn't see that? Well, that's my interpretation.
If you're not screwed on one, you're screwed on the other.
Well, that's my interpretation, because if you argue this, well, then there's this. If you argue that, then there's this. So if you argue that you even if the defense had asked for the video, the answer would be, well, you didn't ask for the metadata, and therefore that's so what?
Okay, so here comes another footnote with another cover for the prosecution. Moreover, during cross-examination, Jackson questioned Buchanan extensively about the video being inverted, and even played a corrected version of the video that was not inverted, leaving no doubt in the minds of the jurors that the video played by the Commonwealth was not a fair and accurate depiction of what occurred inside the Sally Port. Thus, the disclosure was sufficiently timely to allow the defendant to make effective use of the evidence in preparing and presenting her case. So again, because you're so good at your job, defense counsel, you were not prejudiced, therefore we're not going to help you, and we're just moving on.
Yeah, our friend Neil
it's outrageous.
That, right? It's outrageous. And by the
way, to be penalized for being good.
After it says, and I think I just saw a note up there that answered, don't you need the metadata for identification? Yeah, that's usually how you identify properly, is for the metadata, and also to know if things have been changed or not.
Yeah, otherwise, especially these days, to find out, deep fakes and whatever other altered video you can create, without it, who knows what you're really seeing.
Yeah, and then we also have a question from Jason Hodges. Can they appeal this ruling? Good luck on that.
Yeah, obviously, this is if there's a conviction, this is kind of the outline for the first appeal. All of these issues will be thrown back in the form of an appeal if there's a conviction.
If there's a correct, all these issues will come, and then there'll be some other stuff. I mean,
well, during the course of trial, there will be more, right? Things that involve objections, which of course won't have the grounds, so we won't know what they are. That'll be those issues. What evidence is allowed in, what evidence is not, what motions in limine are granted versus adjusted during the course of trial. All that stuff is going to go into the appeal tank if there needs to be one. Remember, we talked about the Jennifer McCabe statement. The whole to me, this was something. I wasn't really that connected to it. I didn't see it as a big thing, but she went and saw. Is it Officer Lank? I want to make sure I give him his right.
Yes, it was Lank.
Sergeant Lank.
It was Lank.
She was going there with a friend who had to pick up kids, and there was or wasn't a conversation. She had said early on that she never went there. It was later determined that she did, and she said, "Oh, I forgot," but then continued to say nothing ever happened. There was no real conversation between Sergeant Lank and herself regarding this case, and so that was an issue that the defense thought was worthy of bringing up in this motion, and they did. I didn't think it was a biggie, and we talked about this too, and I sided with the court, actually, because the defense learned about this visit during trial and during cross-examination. He touched on it, but learned more after the fact, remember? And then the judge said, hey, you want to bring her back? We'll bring her back. During cross-examination, Jackson questioned McCabe about the details of her discussions with Lowley, McLaughlin, and Tully about that trip to Lank's house. She testified when Tully asked if she went to Lank's house on January 30th, 2022. Remember, this would be the full day after the overnight event. At first, I said, no, I've never been to his house. Then I thought about it, and I said, oh my gosh, yes, I did go there, and that was the extent of the conversation. So then she's excused at trial, and it's only then that Alan Jackson is thinking, well, I never got into that because it wasn't revealed till she was excused. He was given the opportunity to bring her back. The court offered to allow Jackson to call McCabe back to the witness stand. Jackson declined, stating, no, Your Honor, I'm not. That's not I think the court understands. That's not my point. My point is not that I need to call Jennifer McCabe back. I've done the damage that needs to be done on Jennifer McCabe. When the court asked, you've what? Jackson repeated, I've done the damage that needs to be done on Jennifer McCabe, and stated, I don't need to call her back. So I do agree with the court on that one very specific issue. He had a chance to call her back. He did trash her. I'm not sure it would have been even more helpful to say, here's one more incident in which you have misled or lied about your involvement. But he had a chance. He didn't do it. Too bad.
Yeah, and it's always a problem when courts offer the opportunity to do something again. I remember, Inspector, we had a pretty severe hung, and the court offered us opportunity because the court wanted to recharge on a theory of the case that Alan Jackson had never put forward, and we said, no, Your Honor, we don't want to have any other. We're not closing on that. Sorry, when courts offer you the opportunity to do something, usually not a good thing. They're not trying to help you generally. They're trying to cover the record. Yeah,
exactly. And it would have been glaring had he not made if he had just said, well, Your Honor, we're not going to do that, and not explained why he wasn't doing it.
But I understand why he did, because remember, the courtrooms this is a media event, right? And so he's saying, I trashed her, and people were feeling like she's trash, and those
gosh, it was brutal.
Oh yeah, and then it was brutal, and then others were people, why are you trashing this woman who's just trying to tell the truth? Micah has a question, by the way. This decision is like filing a claim with your insurance company. Denied for all the reasons. Your surgeon will have to call the day before you're about to die before we approve. And usually then they may deny too.
Yeah, that's true. Or your deductible is so big, it doesn't matter if you got insurance or not. That's a whole different analysis. But I understand the comparison. So let's see if there's anything else I noted on here. I think some of these conclusory statements, by the judge, just the defendant has not demonstrated that she suffered any actual prejudice based on the Commonwealth's late disclosure or failure to disclose evidence before the first trial. Just, okay, so look the other way. Don't worry about it. Let's see. Oh, and this is interesting too. She's basically letting the prosecution and law enforcement off the hook, suggesting none of this stuff, if it happened, even as you say, it was not intentional. Nor has the defendant shown that the Commonwealth's conduct was so egregious, deliberate, and intentional that prejudice should be presumed. So all of these things, Linda, happened by accident. All of them.
Every single last one of them.
You realize that. It was all accidental.
I mean, there should be like the defense obviously argued it. But as I say to people all the time, and I explain to everyone watching that, when the jury's in there discussing things, sometimes it helps to have a checklist, right? And by the way, speaking of checklists, Judge Canoni said it was suggested that under the new Rule 14, there'd be a checklist for people to check off. Did you notice that as to what they're asking for? How about you just save everything and turn over your whole file? How about that?